Hello, today we are going to discuss a case study on the case Taj Mahal Hotel versus United India Insurance Company Limited. The main premise of this case would go something like this. For example, you are visiting a hotel and at night you give your car for parking. Now what if due to some third party your car gets damaged or it gets stolen? Is the hotel still responsible for the losses or do you have to bear them? And now basically we are going to dive into this question within this case. Now let us look up on the facts of what had exactly happened. On 1st August 1998, a person named Sapan Dhawan, the owner of the car, visited Taj Mahal Hotel up around 11 pm, and thus due to the timing, he had offered his Maruti Zen to the hotel for parking services. Once he had given it out, he had received a parking tag in which it was mentioned that any sort of damages or any sort of risks that were involved in parking, they will not be liable or would not be borne by the hotel, and that any damage or risk that would be committed to the vehicle would have to be borne by the owner. Now, subsequently, at around 1 am, when Sapan Dhawan came down, it was found out that his vehicle was stolen. Once this had happened, after further interrogation, it was found out that 3 boys had went and stolen his car. Once they had opted for a valet service, one of the boys had sneaked into and taken the car keys of Sapan Dhawan and drove away while stealing the car. Despite their efforts, the security of the hotel was not successful enough to stop the vehicle. Soon after this, a complaint was lodged in the police station, but the car remained untraced. Sapan Dhawan had opted for an insurance of the car, and thus he had insured this car. After a surveyor from the insurance was appointed in this case and things were settled down, Sapan Dhawan was able to claim an insurance amount of Rs 2,80,000. Now, despite all of this, Sapan Dhawan had executed a power of attorney and a letter of subjugation in favor of the insurance company. Thereafter, they had filed a lawsuit against the hotel to get a form of compensation. Once this file was claimed, the state commission dismissed this complaint because an insurance company fails to be qualified as a consumer. Once this was failed, the insurance company had opted to go for the National Commission. On 20th September 2010, the National Commission observed that the insurance company had locus standi in the complaint and sent the complaint back to the State Commission. After this, the State Commission decided that yes, they could go for a lawsuit against the hotel, and the hotel was liable to pay Rs 2,80,000 along with the 12% interest per annum of Rs 50,000 for Mr. Sapan Dhawan as well as the insurance company for all the inconvenience and harassment they had to go through. Now we shall look upon the few of the statutes and provisions that were used within this case. The first one would be Section 148 of the Indian Contract Act 1872. The second would be the Section 149 of the Indian Contract Act 1872, Section 151 of the Indian Contract Act 1872, and finally Section 152 of the Indian Contract Act 1872. During the hearing of this case, at major 4 questions were raised. Now we shall look upon how these cases were settled and what were the verdicts of the judge. The first question was in regards with the complaint filed by the insurance company as a subrogee. As we know that Sapan Dhawan had given a power of attorney to the insurance company, and at first they were turned back. But later on, as it was found out that since Sapan Dhawan had appointed it as an attorney and moreover also given a letter of subrogation, the complaint was still viable and maintainable. And moreover, since both the company and the owner had complaints, the court held that the complaint was still maintainable. The second question that was raised was in terms of the hotel's liability. Since the Supreme Court had adjourned this case, it had later observed that the hotel's purpose of valet parking, due to mainly this service provided by them, it doesn't matter whether how free or out of what gratuity they were offering. They had to make sure that the good provided, or in this case the car in interest, had to be given back to the owner safe and sound without any damages. Since this whole transaction or this whole activity had come under the Indian Contract Act of section 148 and 149 and it was classified as delivery of the vehicle, thus the hotel were liable to give back the vehicle in its original state without any damages, and if so they had to be compliable and they had to provide any form of liability or any form of compensation in case of any damage. Now the next question that was raised was the required degree of hotel standard of care. Basically, did the hotel take appropriate measures to prevent something of such sorts from happening? After the court went through the whole incident, it was decided that the hotel did not provide any form of adequate measure to make sure that something of such sorts does not happen. And the court also ruled that Sapan Dhawan's car theft was the result of the hotel's negligence. And moreover, under the Indian Contract Act of 1872 and the bailment law, the case of goods were damaged, and in case of any of such happened, the hotel was liable to pay back to the owner under the Indian Contract Act of section 152. And the next question that arises is exclusion of the hotel's liability by contract. Now, as we know, in the beginning, it was mentioned that the parking tag contained a provision in the contract which said that in case of any loss or theft, the hotel was not responsible. But we have to keep it in our mind that these contracts cannot be above the law, and that these contracts were nowhere above the Indian Contract Act of the section 152, and the hotel still had to prove that the vehicle was safe and sound and still had to provide any form of compensation for the loss that had happened. Thus, the court ordered that the liability should be affixed on the hotel, and due to this, they had to take requisite care towards the bailed item. Consequently, the appeal was filed and the case was dismissed. In the end, we could make a conclusion, that is, the consumer complaint is considered maintainable only when the consumer, as you can see, is a consumer, and second of all, under subrogation if they have any form of complaint, and under a power of attorney, and since there was also a letter of subrogation, even the insurance company could appeal for a complaint. Second of all, there is no precedent. This was the first of its kind case, and thus this judgment is used as reference for any form of future cases of such sorts. Finally, it made sure that despite the contract clearly specifying that the hotel was not liable, it just proved that it is not beyond the law, and that as long as it falls within a certain characteristic, basically a section of the Indian Contract Act, the hotel cannot avoid it, and no matter how of what degree the contract exists, as long as it is beyond the law, the hotel cannot go beyond the law, and basically they have to provide any form of compensation or loss what was borne by the owners of the car, in this case Sapan Dhawan as well as the insurance company. Thank you. That's all for this case.